And then we'll go to another side. Yes.
I'm Jacob, UAF up here. And I have a question. Outside of the school setting, has there been any sort of efforts, or what kind of efforts are available in order to employ the positive influences that these circles can have in the home setting?
Well, I can tell you they have a very positive effect in my home setting. My kids, when things get rough, we better get the talking piece, Mom. But other than that anecdotal, we what's interesting here in British Columbia, and I think this was quite unique internationally, is that a number of years ago, a former Attorney General was in power here. This is about the end of the 1990s. His party was really interested in community justice issues and social justice issues, and he did a big tour. He went down to New Zealand and Australia and asking a lot of good questions. And he came back and he developed these things called community accountability programs. And so we have about 60 of them scattered throughout the country. They get a little bit of funding, sort of a little bit more when you're starting up your program, say $5,000, and it goes down to $2,000. But they're scattered around the country, around the province, and some of them more so than others are given additional funding by their local municipality, and they're all doing remarkably different things. They all use different processes. Some use a scripted conference that was, the Wagga Wagga model, or some use a family group conference, some use a peacekeeping circle type process, sometimes do something like a VORP process, a victim offender reconciliation process. They all do something a little bit different, but they all interact with their communities in different ways. So some communities do a lot of circle process, again, maybe in a proactive sense, that they go into PAC meetings, parent meetings for the parents that are involved in the school communities, and they do circle trainings with the PAC or the PTA groups. Some work in schools, some do diversion cases with the RCMP. They're using it all in very creative ways, and we're trying to map that variance currently through a project we have going on here at Simon Fraser University. Does that help?
Yes, very good. Other comments or questions? Other comments or questions?
So this is Aaron Lyons speaking from Vancouver. Am I coming through?
Yes.
So I work as a community-based restorative justice practitioner here in British Columbia. I'm here with the folks at Simon Fraser University. Just to tag on what Brenda was just mentioning around the community accountability programs here, one of the things that I see is that primarily in restorative justice here in British Columbia, the discourse has been around first-time offenders and less serious crime. And that's been the nature structurally of the relationships between community groups and governments and police. Our agency, though, runs a program that's been going on for 20 years. So by way of updating, this is not new. This is not a latest development, but it is an interesting one, I think, in the field. The agency, Fraser Region Community Justice Initiatives, runs a program that works with those involved and impacted by serious crime. So we work at a post-incarceration level in order to facilitate communication and dialogue between inmates and the people they've harmed. In the most serious cases in the Canadian Criminal Code, we can take referrals from both victim side or from the institution side, and it's an interesting experiment and one that's been met with a lot of success. So I just wanted to share a little bit about that as well. Interestingly enough, in terms of our previous conversation around therapeutic jurisprudence, we have found that by making this program not relevant to parole applications or any type of early release, that we're falling in line with what victims have expressed to us around their needs. And that by engaging in a process like this one, knowing that it will not have a direct effect on parole or early release is often an important thing for people who have been affected by traumatic criminal offenses. And knowing that this is purely for a therapeutic purpose on both ends and not affecting sentencing or parole.
Brian, and in Hawaii, we have a comment and then a question.
Yes.
Go ahead, Carrie.
You should go back.
Hi, this is Carrie.
Hi, Carrie.
I've done a bit of facilitating with a program called EPIC, Ohana Conferencing. And Ohana is the word for family, the Hawaiian word for family. And what they do is when a child is, if their safety is in jeopardy in the home, or the child has been taken out of the home, it's a means for gathering the entire family, extended family, aunts, uncles, cousins, collaboratively to determine what is the safest place and home for the child. They have very high success rates. I wish the ED was here to speak more directly to the success rates. But they do a circling format with a hired facilitator and the social worker. And it's the social worker who determines if the extended family has capacity to provide safety for that child, and then they will recommend Ohana Conferencing. It's really a fantastic program and has huge success here in Hawaii.
Brian, did we say something from the University of Puerto Rico? Did we have one more comment from Hawaii and then to Puerto Rico? Okay. I think we had one more comment from Hawaii.
Well, I think she wanted to respond. Did she want to respond to Carrie's comment?
I was going to say it sounds similar to the process. Our Ministry of Children and Family Development use a family group conference, the family group conference that first emerged in New Zealand, which reflects some of their traditional practices, and then moved to Australia, where the sort of private family group time disappeared, and then it came over here to British Columbia. And so our Ministry of Children and Family Development used that. It's not quite as integrated as the New Zealand or some of the Australian type models that vary state to state. But so we use that family group conferencing model where you bring in extended family to produce a plan, whether it's for child protection or for juvenile justice issues. We use it in both contexts, and but it's done through our ministry.
The question we had here in Hawaii was, I was just curious to know, I attended a peer mediation conference recently here, and there were about 7 very eager and involved schools in the program, but one of the things I heard from all of them is that the funding from the state at the state level has continued to wane for about 10 years, and they never see it coming back. Does anybody have any comments about funding issues to support some of these peer mediation programs or bullying programs in the school system at the state level, or is everybody struggling like we are and the schools just have to come up with the money if they want to provide these kinds of programs?
I can speak a little bit to that. Just 2 weeks ago, I was asked to follow up on a conference that was put on by the White House, which followed a rash of high-profile suicides as a result of bullying in school, mostly homophobic bullying. And the White House was very alarmed by these high rates. They responded, and to the White House they invited researchers, families that had lost children, children that had turned their ways from bullying behavior, victims of bullying behavior, and and they launched a brand new website called Stop Bullying Now, which is available. And I know they've now given a lot of targeted funding to address bullying in particular through their Safe and Supported School network. And I sat in and helped facilitate a 2-day webinar on particularly on restorative justice and school bullying, and I was directed to talk about prevention, not punishment. So the tide is really turning, and I think particularly through the Safe and Supported Schools initiative. I can't remember, it's an S32 initiative. I'm not really sure on all the American granting agencies. But I think the tide is definitely turning. The very fact that the conference was in the White House shows that the tide is turning from the previous and maybe current zero tolerance attitudes around behaviors.
That's very good news. Thank you for that.
And then to Puerto Rico, we had, David, did you want to ask that question or make the comment?
A quick comment by me, and then we have someone else here who has a comment or a question. First, I just wanted to say something about the comment from Simon Fraser, which I think is excellent, about how in certain instances having something completely divorced from the legal system and divorced from having any potential impact on an offender's sentence can be great, especially when you're dealing with victims, and it does bring out the bona fides of the parties. So I applaud that comment and that program, and think that there's certainly a place for that, especially when we're talking about victims and offenders willing to meet victims apart from how it may affect their sentence. Really, I think what I was talking about earlier, though it's not irrelevant to victims, is more in terms of an offender's plan for coping, for housing, for reconciling with his or her family, much, I think, in accord with what the Maryland program is seeking to do. So I really think that there's room for this both as a prelude to parole and completely apart from its effect on the length of sentence. Having said that, I'd like to turn it over to someone else from Puerto Rico with a comment or question.
I'm curious as to the dynamics of victim-offender mediation in regards to the types of offenders and victims. What has been tested or has not been, and what the outcomes.
Do you want to speak to that?
That's a good question, and someone from Simon Fraser is going to answer that.
Yes, I'll take a stab at that. No pun intended. I guess in the case of our program, we're dealing a lot with cases of murder. We're dealing with cases of rape and other, very serious physical harm that's irreparable harm that there is no way to make restitution for in other than symbolic ways. And in terms of the outcomes, our philosophy is that, the reason this program exists is to address needs on both the victim side and the offender side that haven't been addressed by the criminal justice system. And there are many. And so success is defined by the needs that participants put forward for themselves and how well the process has met those needs. For some people, it may be about achieving answers to questions that they've had for 20 years following a criminal offense. For other people, it may be wanting expressions of remorse from somebody. Or for an offender, it may be just wanting an opportunity to have a human-to-human experience with the person that they know that they've harmed and have caused this trauma to. There's many different types of needs that people would bring. And the studies that have been done on the program have shown that in meeting those needs, it's been very successful. I think the last really conclusive study was in 1998, quite a long time ago, on victim offender mediation program, on this particular one. And showing that satisfaction rates were extremely high, near 100%. It depends what we're measuring. And I guess if it's about measuring recidivism, it's also true that we have a very strong correlation between those who go through our program and low rates of recidivism. Personally, I'm not convinced that that's an easy equation to make. I'm not a researcher myself. I see the good in this and see the profound impact that it has on individuals. And I think there's a lot more research that could be done.
We have one more, Brian from Puerto Rico.
Okay.
Hi, my name is Jose Service. I'm from the University of Puerto Rico Hospital. I wanted to talk specifically about the Ohana initiative and the Circles initiative. Either one that could answer would be fine. I want to use an example here from my reality. And in Puerto Rico, it seems as though when crime rates go up, everybody agrees on the fact that it's a problem that starts at home. But the reality is that very little is done by the government to commit funding for preventive measures like the ones that you have talked about here today, which just sound real amazing. I wanted to know how much of an uphill battle has it been over there to explain to the government how important it is to invest in the long term and not just on the short term, which seems to be obviously a political matter, to invest in a more punitive approach to resolve the problem in the short term, but not to invest as much in long term.
That's a great question, and I wish I could say our government is investing in, harm reduction rather than punishment. But I'm sorry to say that, our response to crime and harm and justice issues waxes and wanes with political shifts in our governance. And the glory days of the late 1990s with the evaluations that were being done that Aaron referred to, and that when our former Attorney General was developing these community accountability programs to have more community-based justice initiatives, what the research basically shows is that it's just like it's about empowering the bystanders in the school courtyard. Crime reduction happens when you empower the community. So it's really the basis of where the funding needs to shift to is empowering communities and NGOs, which are closer and more responsive to community needs, in line with the idea, say, of responsive regulation that comes out of John Braithwaite's work. That the level of the state is too abstract from the reality of individuals' lives, and we need mediating institutions at the level of community to be better responding. So where are we finding that? We are actually reducing harm and keeping people out of harm's way. And so the organization that comes to mind for me that best exemplifies this, because they do a lot of programming. They use circles. Both within their institution and with the young people that they serve. What most people do when they find out about circles, they say, "Oh, that's a great thing. I'm going to start using it for the juveniles, the bad apples in my community, because we're going to develop a circle of care around them." But this organization in Boston, Massachusetts, is called ROCA. It stands for rock in Spanish, because that's the population that they mostly serve. When they first heard about circles and the circle processes that emerged from the Yukon territory, and we basically exported to the States, and the States are doing more work with them than we are these days. But this organization called ROCA first started using circle processes to transform the way they relate to each other within their own organization. And once they had that in place, they started using the circles to develop transformative relationships with the young people that they serve. And they work with young people that everyone else has given up on. They're the kids on the street, on the corner, involved in gangs. They're recreating their social world through the gangs. And so they use these circle processes not only in that capacity, but through these circle processes, they've reinvented themselves in light of the institutions that also serve these young people, like the police, the school district, the district attorney. I've sat in circle in Boston with all these people, and in fact, they have such a reputation now. When the chief of police retired, and he used to be the person that was always being yelled at, you just don't understand my kids. They're my kids. You don't understand. Creating this sort of adversarial relationship between the police and this advocacy group for youth. And then they said, well, we need to transform that relationship too, and they did that. And the chief of police retired and went to work for ROCA. It's a great testament. So now they're doing a replication of ROCA at a different site in Massachusetts, in Springfield, Massachusetts. And they're partnering with the university there. That's also an important partnership to form. And so I encourage you all to do a web search for ROCA in Chelsea, Massachusetts. They are on the cutting edge, from my point of view.
That's very good. I wanted also to bring in Val Binder from Whitehorse, from the Yukon College in Whitehorse, and just to say a few words about what's happening in Whitehorse to complement what you're saying, Brenda.
Great.
Hi there. Actually, Joanne was going to speak to this, but she had to step out for a moment because she was going to speak to the whole big picture. I, of course, only can speak to my position as a restorative community conference coordinator for YTG Youth Justice. But within the Yukon, we all know that we have we have 9 justice committees throughout the whole territory that each individually work within their own communities to meet the needs, either through conferencing, circles, talking circles, healing circles, whatever process they need. We have a DVTO, Domestic Violence Treatment Option Court, which is not unlike the therapeutic jurisprudence that was spoken about earlier. What's the other court?
Community wellness.
And we have a community wellness court. Again, the same thing that focuses on creating that wellness from within. Joanne really would have spoken to that. I can't speak to it. But conferencing, the Restorative Community Conferencing Program through Youth Justice, that continues, as well as we have a family group conferencing model through Health and Social Services. Now, luckily for you guys, Joanne is coming back. I just asked him the question about what are we doing in the Yukon.
Okay.
I touched on it, but maybe you can speak to it better. Is that all right? Brian,
Yes.
are you okay with that?
Yes. Very good. Thank you.
Okay, thanks, Brian. Thanks, Val. I'm not sure what Val has mentioned in the last couple of minutes, but we do have 2 therapeutic courts in the Yukon. We have the domestic violence treatment option, which has been going for a number of years. Can you hear me?
Yes. Yes. Yep.
Okay. And we also have the community wellness court, and that's been going, I think, for maybe 2 years, maybe 3 at the very most. And both of those courts are alternatives. They are there for people who have decided that they want help dealing with their issues. And the court oversees a fairly intensive program plan, case management plan, and there's frequent reporting. I can't give you much more information than that because we don't have anyone here from Justice who can speak to it. But there are those courts, one going for a number of years and one fairly recent. And Val probably talked about the Community Justice Committees.
Briefly.
Okay, we've got 9 of those in the Yukon in, I think it's 8 different communities. And what they do varies from community to community, and it's determined by what those communities are able to deal with or have said they want to deal with. And so some may be involved in family conferencing, some may do other things. So it varies, and it's not in every community, but it is dependent on the people who are there as to what they do, what issues they deal with. And they are involved at various points in the system. Those committees are funded by the Yukon government and the federal government.
Just to say, we don't have the struggle here like I know that United States and the state of Alaska has with funding. We're very blessed in that sense.
If I could just add something, it's Mark from Whitehorse. So I've been involved in some, I suppose, therapeutic jurisprudence models over the years. And I think in the Yukon we are blessed, as the other 2 have said, with a very proactive legal institution. We've got some very pro-therapeutic jurisprudence lawyers and judges who are very, very keen to push that agenda. But with the whole notion of community justice, the problem becomes somewhat complicated, because oftentimes you have people that are moving through some kind of therapeutic process, oftentimes with the usual problems you would expect, probably very, very similar to what I heard you folks in Alaska speak about. So numerous addictions problems, mental health problems, very, very dysfunctional relationship situations. So the challenge then becomes, if you put the community back in community justice, how is the community able to monitor effectively somebody on some sort of therapeutic disposition? That's become a huge headache, because I've attended numerous circle sentences where the actual process itself has been very, very powerful, very moving, very engaging, and at the end of it, it's been an incredibly cathartic experience for everybody involved, offender, victim, families, and so on. But the problem then becomes with the follow-up. So how do you ensure that whatever contract, if you call it a community living contract, that was produced in the form of a sentence, how is that actually supervised, monitored, and resourced in communities that often do not have very much in the way of those resources? The Yukon is not well provided for in terms of its mental health resources, especially in communities. So those kinds of challenges, it seems that the legal institutions are way ahead of our social institutions in terms of being able to pick up the slack. So, I think there's some great work happening in the Yukon. There are some wonderful people within the legal profession that are really pushing the therapeutic jurisprudence agenda, but we need the resourcing, and we need, honestly, the sort of on-the-ground community buy-in to support offenders and victims after they have gone through whatever process they are going through.
So I just wanted to, just have Jeff May from Alaska to speak just briefly to the a model of conferencing that Val does, very briefly, and then we'll go to another site. Jeff.
Okay. Yes, thank you. First off, for those of you tuning in from the other universities, we were very fortunate last year. Val Binder from the Yukon was very kind and generous to come here and provide us some greater training and insight on the conferencing model that she is involved with. And to that extent, I'm in the process of writing a paper about that to try to promote that with other areas. But I was wondering if you could address the difference. It seems like you're talking about 9 community justice committees, and it seems like you're addressing those as those are different groups than the current conferencing model that your Department of Health and Social Services is operating. Could you address that difference, if there is one?
Hi. Yes, Jeff, I could do that for you. And you know what? I have to just say straight up, I only found your article today on the site. So it hasn't been reviewed by the government. I kind of went through it really, really quickly. I should talk to you about some of the language in it. So maybe we'll email at some point. Because, when I trained there, you guys kept laughing at the Canadian usage versus American usage of certain things, such as felt pens. However, there is a difference between what I do and what the justice committees do. My role as the conference coordinator is mandated under Section 19 of the Youth Criminal Justice Act. So it's a provision under the Act that says conferencing will be provided for youth. There are 6 people that can convene a conference, and then the conductors of conferences are people who are trained, such as the training that I provided for you guys.
10 conferences over here.
Now, justice committees are committees under a separate department. I work for Health and Social Services. Justice committees work for Department of Justice. And so those committees are funded under a different program, and those justice committees, there's 9 of them throughout the territory, they are separated by the departments. However, I still provide training for them, and we work hand in hand basically in trying to provide supports in the training as well as meeting the needs of the community, because regardless of whether a youth or an adult lives in one community or another community, we all work together. It's a small territory. In fact, on Friday I leave to go to Old Crow to provide training and supports to the Community Justice Committee for Vundek-Witchin in Old Crow. So they are separate. That's really important to know that they are separate. I work for a government. Everyone else, those justice committees, either work for a First Nation, or in the case of Dawson City Community Group Conferencing Society, it's a NGO. Does that answer your question?
Yes, thank you.
Very good. Other comments or questions?
Yes, we do in Hawaii. We'd like to address Puerto Rico on an issue of funding for interventions in the homes that was brought up. And Carrie Urosevich will take the floor.
Hi, my apologies. It's me again. This is an area in which I've worked for the last 10 years, and it's particularly frustrating for me to see the lack of federal and state funding that goes into prevention that starts in the home. If you see violence rates in the United States, they have determined that 85% of felons that are in our prisons were abused as children. And so I think what the gentleman suggested and put forward from Puerto Rico about saying this starts in the home, I don't think there's any question that that's where it begins. In the state of Hawaii, there are many programs that are partially funded by the government. The rest of the funding comes from private funds. They have high success rates, but the 2 most challenging aspects I find are, one is changing the attitudes about child abuse in particular. In the United States, there's definitely an attitude of, who are you to tell me how to raise my child? And there's a protection around that, and that becomes very challenging. How to define child abuse is also very challenging within the home, and what are the parents' rights in determining what that will look like and what that discipline looks like. The other challenge is trying to measure preventative programs so that you can show success. So the positive parenting programming that I've been working with, we have to show the state that we are actually preventing, and to do that qualitatively is very challenging for us. We do it through exit surveys, through the programs, to say what were your attitudes coming in around spanking and hitting and using corporal punishment in your home versus when you came out of the program years later. And those are remarkable because they're powerful testimony, but it still is not determinate in terms of repeat offense. And so we find those 2 to be very challenging here in the United States.
Okay, I'd like to switch gears now and maybe ask Tom in Salisbury University, to talk a little bit about current controversies in mediation and related practices, and theory to practice gap in dispute resolution that we often see. Anybody from, I invite Salisbury generally, but Tom to lead off and talk a little bit about the current controversies in mediation.
Well, Brian, I think your own paper on integral mediation speaks very well to that. And I share your concerns, and we talked about it a lot when we were together, that there already, it seems to me to be, as you describe it in your paper, the branding and championing of specific types of mediation over others without looking at the specific case before mediators. And you notice in your paper the several different schools of mediation. I think we're just too young a discipline to have cults within the mediation framework of various schools of mediation. And so I like your idea of integral mediation, and particularly the parts on knowledge production. I think as an interdisciplinary field, we can make a distinctive contribution to how we understand not only specific practices and the connection between theory and practice, but also what type of knowledge is presumed in that process, and also what type of knowledge is created and privileged, and by whom. And I think your paper spoke very clearly to that, and I especially liked that section on the construction of knowledge, as well as the section on grounded theory. As Dr. Polkinghorne, my colleague here, states, you have to let the data do the talking. And I'm concerned in mediation that we impose theories upon the mediation rather than look at the mediation and try to decide which theory fits or if theory fits at all. So I think there are problems, and I thought your paper is a very important beginning in addressing those problems, because it's simply too premature to have these different schools of mediation in theory and